And there are once again talks that what the government was not able to do in the 26th Amendment, they will now attempt to do through the 27th Amendment.
Now, through the 27th Amendment, they seem like they want to erect a tombstone or a monument on top of that grave.
One thing that does come to mind is why do they need a federal constitutional court? They have a constitutional bench that is basically doing everything.
You don't have situations where, parliamentarians are summoned at 4 a.m. in the morning and told to, play, put their hands up and vote for a bill that they haven't seen.
I'm Rida Hosain, and in today's case in point, we're going to talk about reports regarding a possible 27th Amendment to the Constitution. Last year in October, the government managed to pass the 26th Amendment to the Constitution. At that time, a significantly watered down version of the constitutional amendment was passed. There was a bill that surfaced around that time which established a federal constitutional court. There were talks that the government wanted to expand the jurisdiction of military courts and also to allow for the transfer of judges from one province to another without their consent. But at that time, the government didn't have the numbers and there was significant opposition and it was not able to pass that bill. And then eventually the 26th Amendment to the Constitution was passed. Thereafter, however, post the reserved seats decision, the government and the ruling alliance now does have a two-thirds majority, and there are once again talks that what the government was not able to do in the 26th Amendment, they will now attempt to do through the 27th Amendment. To talk about this, we have with us Salahuddin Ahmed, who is an advocate of the Supreme Court and also a former president of the Sindh High Court Bar Association. Sir, last year the 26th Amendment was passed. It's not even been a year since the 26th Amendment has been passed. There are several petitions still pending challenging the constitutional validity of that amendment. And now we're hearing that there's a 27th Amendment on the cards. How do you look at all of this?
Well, as far as the 26th Amendment is concerned, I think the 26th Amendment, through the 26th Amendment, the government and the establishment successfully buried any notion of an independent judiciary. They dug the grave and they buried the judiciary there and then. Now, through the 27th Amendment, they seem like they want to erect a tombstone or a monument on top of that grave. And that's the sum of it, really. What we're hearing is that one thing that they didn't do last time was that they didn't set up a separate constitutional court. They only set up constitutional benches, which also operate for all practical purposes in the Sindh High Court and the Supreme Court as a court within a court. We've seen them, setting aside orders passed by the actual court. We see them, they obviously have powers to constitute benches, etc., by themselves. They pick and choose what cases they want to listen to, even if they are being heard by other benches. So, but now apparently the government feels that they want to go one step further and they want to have a completely separate constitutional court, both for the in the federation and about the provinces. We hear there'll be different courts. There'll be a separate Supreme Court for the provinces and separate constitutional courts. Then we're hearing that they will, pass some requirement for fresh oaths. So, of course, fresh oaths are a very, in Pakistan, we've seen lots of fresh oaths of judges. Pretty much every time a military dictator comes in, he prescribes a fresh provisional constitutional an oath under the provisional constitutional order. And that basically, the text of the oath is usually with some differences. It's broadly the same, but its real purpose is to weed out any undesirable judges and to ensure that the remaining judges reaffirm their loyalty to the regime of the day. I don't see any difference in the requirement of fresh oath that is now being proposed. At least as far as the transfer of judges was concerned, um, in the Islamabad High Court, they went ahead and made those transfers, and the government was successful in establishing its control over the Islamabad High Court because they saw the existing judges of the Islamabad High Court as being hostile to them. So they took judges from outside and they clamped down on that court. It was challenged in court before the Supreme Court. The constitutional bench said it's okay, but quite clearly there were, and even the judges who said it was okay, even they pointed out, a lot of flaws in the process and the fact that the existing constitutional articles didn't seem to contemplate these kind of transfers. So those kind of lacunas now they want to fill in, apparently. And since the constitutional bench has, awarded the government allied parties a two-thirds majority, they've taken those seats from the PTI and awarded them to the PMLN and the PPP, etc. So now they have, all the power to do so.
So you talked about a federal constitutional court, which the government tried to do last year as well, but they didn't succeed. And one thing that does come to mind is, why do they need a federal constitutional court? They have a constitutional bench that is basically doing everything, that is endorsing their position, and that has so far only endorsed the government's position in all significant cases that were before them. They upheld the court martial of civilians, they upheld the trial of civilians by military courts, they upheld the transfer of judges, partly referring it back to the president, but they upheld that transfer. And they also, as you said, gave the government a two-thirds majority by taking away PTI's share of reserve seats. So there is a question which arises as to, now, do they completely want to abolish the Supreme Court and for there not to be completely redundant? Because the present system also seems to be serving the government and seems to be serving its interests. And when it comes to what is the role of civil society, the role of lawyers? At the time of the 26th Amendment, there were petitions by a cross section of society challenging these amendments and requesting that they be struck down on both procedural grounds as well as substantive grounds. But we saw a kind of judicial paralysis in the Supreme Court where these petitions were not taken up. And now it's almost been a year and these petitions haven't been taken up. There's, I think, only been one hearing on them, and there's not been any significant progress on these cases. So when your Supreme Court is in a state of effectively paralysis, where petitions you're filing are not being heard, where you have two judges in the Supreme Court, we had Justice Mansoor Ali Shah and Munib Akhtar, saying that list these petitions, put them before a full court. Now today there has been a letter which was released by the Chief Justice, who said that he didn't feel the need to do this because he had informally asked the other 13 judges, who had said that no, a full court cannot be formed. So how do you see all of this, and what can we really do when the court is itself, as I said, in a state of paralysis?
Well, first of all, as far as the need for a constitutional court, I think part of at least what we are hearing, obviously, there's no actual concrete document as yet or a draft, etc. But what we're hearing is that the Constitutional Court will have a higher age of retirement. So that will allow the government to ensure that presently judges who might be on the constitutional bench and may stand to retire, either this year or next year, etc. Those people can be given a longer tenure, if the age of retirement is extended for the Constitutional Court from the current 65 in the Supreme Court to 68 or 70, whatever. So it gives a greater permanency to the new regime. As far as you mentioned the different petitions against the 26th Amendment, now the first petition, as far as I recall, was filed I think about 27th October last year. And for about a month and a half, those petitions were not even, the office refused to assign them a number. There were no objections on the petition, nothing. But for a year, for a month and a half, there was, the Supreme Court office just said we won't number these petitions, which, at least in my 25-year experience, is unprecedented. Then after that, then a few months passed. For about a month and a half, the constitutional bench just kept on hearing petitions that have long become infructuous, like petitions relating to RFLV's presidency or Justice Faiz Isa's appointment to the Balochistan High Court. These kind of completely stale dead issues were taken up by them for about a month and a half. Then they started hearing the military courts matter. And basically, throughout, there was no hearing of the 26th Amendment. There was one day it was fixed for about, notice was ordered in a hearing that lasted maybe, 45 minutes, an hour. And then after that, for the next 6 months, again, the 26th Amendment petitions were, not ever listed. You speak of paralysis. I think paralysis is too passive a word. I think there is an active avoidance of these issues because there are serious problems with the 26th Amendment. And the constitutional bench or the Supreme Court just does not want to face up to them because obviously that, will involve a further discussion and debate of the Supreme Court's role, etc. And, they want to avoid that. Now, as far as you mentioned, Chief Justice Yahya Afridi's refusal to convene a full court for the 26th Amendment challenges. Now, as far as I understand it, the law at that time was quite clear, right? Cases had to, at that time, under the practice, obviously the amendments have been made later on, but at that time, under the Practice and Procedure Act, if there was a challenge to the constitutionality of any act, that had to be decided by the committee. Two members of that committee said that this should be placed before a full court immediately. Chief Justice Yahya Afridi was in the minority. So the law mandated that he had to put it before the full court. Now, the note that has recently come to light, his note, that says the reason I didn't put it before the full court is that I informally sounded the other judges, and the majority of them said, no, there's no need to put it before the full court. Now, with respect, that course of action was completely illegal, right? The law said that if the committee had decided by majority that it has to be placed, so the Chief Justice had to follow the orders of the majority. Now, once it was placed before the full court, let's say if there was actually 8 or 9 judges who had said that this matter shouldn't even be placed before the full court, it should go before a constitutional bench, which had yet to be formed at that time. But if the 9 judges actually thought so, then they could have sat in the full court and they could have held that, no, we don't think we have jurisdiction, we should wait for a constitutional bench. But that was a judicial order that had to be passed. This whole procedure could not be bypassed, by informally calling judges. And, then I suppose there'll be, if you say 9 judges said this, 6 judges said that, it's a he said, she said kind of thing. It had to be placed before the full court. And the argument given for not putting it before the full court is that the Chief Justice felt that it would impair the collegiality of the court. Now, I don't understand that reasoning either. The job of the Chief Justice is not to make friends and influence people. It's to follow the law. And you can't, refuse to follow the mandate of the law on the pretext that, maybe there'll be a disagreement amongst judges. Judges disagree all the time. That's part of the, function. I've never heard this rationale that because I didn't want to have a disagreement amongst judges, therefore I didn't list the case before the full court. I didn't take the matter. Even forget the judicial full court. If the Chief Justice felt that the judges should all be consulted, then he could have easily called an administrative full court meeting and placed it before them. Should this matter be listed before the full court or not? So, avoiding that, in my humble opinion at least, was an unlawful step.
So the language that you've used is you've called it unlawful. You've said well, what the Chief Justice did is illegal. And there has been opposition and at least a little bit of resistance within the Supreme Court to what the Chief Justice has done by failing to list the 26th Amendment challenges. But also, I want to ask you that what is the role of sitting judges? So when you have sitting judges, there are clearly at least 4 or 5 of them opposed to what the Chief Justice is doing or have been opposed to some of his actions, and there's still an active surrender in the Supreme Court where even if they're opposed to it, there's an acquiescence that, okay, this is the status quo and we have to accept this status quo even if we may disagree with it. And we've seen in the past that when Chief Justices have taken steps which have been unlawful, only after they've retired have other judges spoken up that, okay, this was wrong, this shouldn't have been done. But when there is a sitting Chief Justice whose conduct or whose actions are in question, what about the role of the other judges who clearly disagree with what this Chief Justice is doing? Should they then just sit there and acquiesce and accept the status quo and surrender that this is just what it is before us? So do you think that they have a duty to do something more than just accept the status quo? And the second thing I'd want to ask you, which ties in with what you said, that about the failure to list the 26th Amendment challenges, what happens to the decisions taken by this constitutional bench? Will they just become past and closed transactions? Because if it was found that this constitutional amendment was void, it's unconstitutional, struck down, does the court that hears that have to ultimately uphold their decisions, or can they also say that all decisions taken by this constitutional bench, those are also now in question?
As far as the duty to protest is concerned, now, I mean, there has been some letter writing which has, come forward. There have been instances of regular benches taking up, the issues of constitutionality and trying to examine whether after the 26th Amendment, regular benches are completely denuded of their power to examine constitutional issues. That was taken up by one regular bench. And then we saw that the constitutional bench suddenly interrupted all its other proceedings and picked that case up, and they said, well, nothing doing. This can only be examined by the constitutional bench. The registrar was directed to go bring the file from that other bench and place it before them, and then they said that the regular benches can't do anything. So, I mean, I think apart from these kind of steps, I mean, the only other avenue of protest would perhaps be resignation, right? And I don't think that that would be, a particularly effective form of protest. I think the only way the resistance within the Supreme Court can be done is that whenever you get an opportunity to sit on a bench, sometimes, one or two people, undesirable judges will also be included in benches hearing important cases. The duty is to voice your true legal opinion wherever you can. Beyond that, of course, judges are not politicians. We don't expect them to be politicians. We don't expect them to act, like bar associations either. So I think that is about all you can expect in the present circumstances. The other question that you talked about, you asked was, I'm sorry if you could summarize that again.
Just about what happens to the decisions taken by this constitutional bench? Are they
Right.
saved?
So as far as that is concerned, again, it really depends on the bench hearing that. Now, let's say, sometime in the future, um, it is actually decided that the 26th Amendment was contrary to the basic structure, to the essential features of the Constitution. Therefore, it should be struck down. Then the next question before the bench that passes that decision will be what is to be done with all the acts that have been based on the 26th Amendment. Now, it is open for the court to strike down all those acts and decisions as being based on a fundamentally unconstitutional action. It is also open for them to save some of those acts by employing the doctrine of de facto, which is basically that, even if something was not done in the legally correct manner, but because a lot of water has flown under the bridge, so it would create chaos to completely go to zero, and therefore they can save some of it. That decision would have to be taken by that bench at that time. Which of the decisions should be saved? I mean, a lot of things. For example, judges have been appointed under the 26th Amendment. A question would be whether all those judges to the Supreme Court and the High Court, whether all those judges should be reverted, back to the original position. Now, it has happened, for example, in the past, in 2009, when there was a brief interim, unconstitutional arrangement, and a lot of judges were appointed during that the second martial law of Pervez Musharraf. All of those judges were sent back. There are previous precedents also where some of them have been saved. For example, in Al Jihad, when they held that the appointment of judges was unconstitutional, but they said, look, we don't want to completely upset the apple cart. What we'll do is we'll do a review of all these judges and see which ones we want to retain, which ones we don't, etc. So then that comes into kind of the discretionary purview of that bench if and when it does decide that the 26th Amendment has got to go.
And we've talked about the role of the judiciary and what judges can reasonably be expected to do given their oath, given their duty. But if we can just lastly talk about the role of the government and the role in a parliamentary democracy like ours. So we saw last year that first there were denials that any constitutional amendment is being tabled or not. The government wasn't being upfront. There was a lot of secrecy surrounding the whole process. And then overnight, one day, there was a bill. And then eventually, very soon after that, it was passed without any debate, without any meaningful consultation. And then now it's a constitutional amendment. And the process of striking that down, the grounds for striking that down are vastly different to ordinary legislation. And you have the National Assembly rules, which also mandate that any bills are to be published. But the government seems to be operating with a lot of secrecy. Everything that they do with regards to constitutional amendment, judicial changes to the judicial structure, they're not being honest about it. They're not being upfront about it. And they continue to deny it. Even now, when there are talks about the 27th Amendment, it's only certain journalists who are reporting on it and the opposition leaders which are speaking about it. There is a level of silence from the government, which is what we saw them do last year. So why is the government being there's so much secrecy surrounding this process? And what is the duty of a government in a parliamentary democracy when they are making such wholesale changes to your entire judicial structure?
So I think that both in government and with political parties, with ostensibly democratic political parties, and within the judiciary itself, judges, they tend to pay a lot of lip service to the forms of democracy, and they pay absolutely no attention to the substance of democracy. right? Now, the whole democratic procedure, the reason why Parliament is empowered to pass laws, to amend constitutions, etc., is because they are supposed to be representatives of the people. And the whole concept of Parliament is that when you're making laws, when you're doing constitution making, which affects the entire citizenry, those things are openly debated. The pros and cons are laid out, before a representative forum, and then you achieve some kind of consensus and move forward. You don't have situations where parliamentarians are summoned at 4 a.m. in the morning and told to play put their hands up and vote for a bill that they haven't seen. And when po- politicians or when judges call that as being the will of the parliament or being the will of the people, then it's a joke, really. Now, in other countries, there has been jurisprudence about that. For example, in South Africa, their constitutional court has actually struck down legislation on the basis that the procedure through which that legislation was introduced was not sufficiently transparent, that the people were not consulted, relevant stakeholders were not consulted, debates in parliament were not held, and some basic law has been changed, and those laws were struck down over there for procedural ultra vires. And I think that that is, a much better way of looking at this process and the substance of democratic procedure of making laws.
Thank you so much, sir, for your time. I think that it's really important for us to highlight what happens in other jurisdictions as well, because oftentimes the government and their representatives say कि ये तो बाहर तो ऐसे ही होता है, आप लोग क्यों इतनी तनकीद करते हैं, but बाकी jurisdictions में ऐसे नहीं होता, the way that they're trying to pass these constitutional amendments. And we just hope that this time around, if there is a constitutional amendment, if there is a 27th amendment, at least the process we can appeal to the government should be far more transparent and open than it was at the time of the 26th Amendment, where it was shrouded in secrecy, and you ultimately had senators appealing to the Supreme Court saying that they casted their vote under duress, that they casted their vote, they were coerced. So we hope that if there is a constitutional amendment as far as the government is concerned, that there is more transparency and more consultation with all stakeholders.